Hello everyone, welcome back to Legally Dephine. In this video, we are continuing with our topic, the structure of Zimbabwean courts, with specific attention to the civil courts, which are the Magistrate Court, the High Court, the Supreme Court, and the Constitutional Court. Take note that we have already covered criminal courts in our previous videos. If you haven't watched those, there should be a pop-up on your screen. Don't forget to like, subscribe, and share. For better understanding, let's start by discussing the general principles of jurisdiction. This is important as it will help us understand the courts better. Jurisdiction refers to the authority or competence of a particular court to hear a matter which has been brought before it and to grant relief in respect of that matter. It is important for the parties or counsel to the plaintiff, as part of its preparations to a case, to be able to determine whether a court has jurisdiction to hear the matter. The effect of a party issuing a case in a court with no jurisdiction might result in the court refusing to adjudicate and dismiss the matter. The court may also order the plaintiff to pay wasted costs. Therefore, it is very important for the plaintiff to choose the court with the right jurisdiction, as failure to do so allows the opposing party to defeat the claim without even entering into the merits or substance of the claim. Let me simplify it even further. If you issue a case in a court with no jurisdiction, the court may not even hear and determine the matter. And on top of that, you may end up paying money for wasting the court's time. Now that we have covered the general principles of jurisdiction, let's continue with our court, starting with the Magistrates Court. In a civil case, the magistrate sits alone. He or she may appoint one or more persons to sit as assessors and assist in an advisory capacity, but such appointments requires the approval of the Minister of Justice. The person appointed must be willing to serve and have skill and experience in any matter to be considered by the court. Unlike in a criminal case, an assessor appointed in a civil case only sits to advise and has no voice in the findings of the court on both matters of fact and matters of law. Take note that in practice in Zimbabwe, it is very rare for assessors to be appointed in civil cases. In civil cases, the jurisdiction of the Magistrates Court is the same regardless of the seniority of the magistrate presiding over the matter. It is different from criminal cases where magistrates are divided into 4 classes of ordinary, senior, provincial, and regional magistrates. A magistrate court has jurisdiction to apply both customary law and general law in its determination of civil cases. The general rule is that a magistrate court only has jurisdiction in a civil case if the amount claimed does not exceed its prescribed monetary limit of jurisdiction. If the defendant resides, carries on business, or is employed within the province where the court is situated, or the cause of action arose wholly within the province. This is in terms of Section 11, subsection 1A of the Magistrates Court Act. Section 11, subsection 1A reads, "Every court shall have in all civil cases, whether determinable by the general law of Zimbabwe or by customary law, the following jurisdiction, excepting any other jurisdiction assigned to any court by this Act or any other enactment, the persons in respect of whom the court shall have jurisdiction shall be any person who resides, carries on business, or is employed within the province, any partnership whose business premises are situated, or any member resides within the province, any person whatever in respect of any proceedings incidental to any action or proceedings instituted in the court by such person himself, any person whether or not he resides, carries on business, or is employed within the province, if the cause of action arose wholly within the province." Take note that the mandatory limit for jurisdiction of magistrate court is adjusted from time to time. There are some cases where the magistrate court have no jurisdiction, and these are specified in terms of Section 14 of the Magistrates Court Act. These include disputes in respect of the validity or interpretation of a written will, the status of a person in respect of mental capacity, and the dissolution of a marriage which is not solemnized under customary law in terms of the Marriages Act. In civil cases, the judge sits alone. He or she may appoint one or more persons to sit as an assessor or assessors and act in an advisory capacity in terms of Section 5 of the High Court Act. Section 5 of the High Court Act reads, in any civil case before a judge of the High Court, the judge may summon to his assistance to act as assessors one or more persons who are willing so to act and who have skill and experience in any matter which may have to be considered in the case. Any assessor summoned in terms of subsection 1 shall act in an advisory capacity only and shall not be entitled to a vote in the decision of the court. Just like in a magistrate's court, an assessor appointed in a civil case must be willing to serve and have skill and experience in the matter to be considered by the court. Section 5 subsection 2 of the High Court Act also made it clear that such an assessor can only sit in an advisory capacity and is not entitled to vote in the decision of the court. Section 13 of the High Court Act states that the High Court shall have full and original civil jurisdiction over all matters and all persons in Zimbabwe. This means that its original jurisdiction is unlimited, and there is no limit to mandatory claims that may be brought to the High Court. And the High Court can hear any civil dispute regardless of the nature of the claim. Therefore, the High Court can hear any civil dispute regardless of the nature of the claim. The High Court enjoys what is called inherent jurisdiction. This means that the High Court always have jurisdiction unless prohibited by some other law. This jurisdiction is superior to that of any other court because all other courts can only exercise jurisdiction specifically granted to them by the enabling statute. The fact that the High Court's original jurisdiction is unlimited means that all matters that may be heard by the Magistrate Court can also be heard at first instance by the High Court. A litigant can sue in the High Court, even in matters within the mandatory limit of jurisdiction of the Magistrates Court. The High Court can only refuse to entertain a case if there is a law prohibiting it from exercising its jurisdiction. You may be wondering, why even bother going to the Magistrate Court instead of just going to the High Court in the first instance and have your matter heard and decided by the High Court? The answer to that is very simple. It's a matter of costs. It is more expensive to sue in the High Court than in the Magistrate Court. Hence, for small claims, it may make little economic sense to sue in the High Court than in the Magistrate's Court. The High Court also have appellate jurisdiction in civil cases. An appeal only goes to the High Court if there is a specific provision in a statute granting the right of appeal to the High Court. Appeals from the Magistrates Court goes to the High Court in terms of Section 40 of the Magistrates Court Act. Apart from being an appellate court, the High Court also have inherent review powers over the proceedings of all inferior courts and tribunals in terms of Section 26 of the High Court Act. A review is not concerned with the merits of the decision, but with the decision-making process itself. In exercising its review powers, the High Court may set aside the proceedings of an inferior court or tribunal. The High Court also have jurisdiction in constitutional cases. The Constitution of Zimbabwe gives the High Court the power to adjudicate over constitutional matters. It provides that the High Court can hear and determine on constitutional matters, with the exception of those that only the Constitutional Court can entertain. This is provided for in the case of Tetrad Investments versus Large Data Enterprises. Without dwelling much on the case, it was held that in terms of Section 171 of the Constitution, the High Court has power to hear and determine on constitutional matters. I do urge you to go and read the actual case for further understanding. The composition of the Supreme Court is provided for in terms of Section 3 of the Supreme Court Act. In terms of Section 3 of the Supreme Court Act, the Supreme Court is duly constituted if it consists of not less than 3 judges, one of whom shall be either the Chief Justice or a permanent judge of the court. It may be composed of 2 judges when hearing an appeal from any court other than the High Court, provided this happens on the directions of the Chief Justice. If an appeal involves a difficult or an important question of law, the presiding judge may order that the appeal be heard by a greater number of judges. In such cases, the Chief Justice determines the size of the reconstituted court. In a matter involving the application or interpretation of the Constitution, the Chief Justice or the Minister may direct that the court be constituted by not less than 5 judges. The jurisdiction of the Supreme Court is provided for in Section 169 of the Constitution of Zimbabwe. Section 169 stipulates that the Supreme Court is the final court of appeal for Zimbabwe, except in constitutional matters over which the Constitutional Court has jurisdiction, and an Act of Parliament may confer additional jurisdiction and powers on the Supreme Court. The Supreme Court is the final court of appeal, and it has no original jurisdiction, thus it cannot be a court of first instance. Its jurisdiction and procedure is elaborated in Part 4 of the Supreme Court Act. The composition of the Constitutional Court is specified in Section 166, subsection 1 of the Constitution. Section 166, subsection 1 reads, "The Constitutional Court is a superior court of record and consists of the Chief Justice and the Deputy Chief Justice and 5 other judges of the Constitutional Court." In terms of Section 4, subsection 2 of the Constitutional Court Act, for the purpose of exercising its jurisdiction in a case concerning alleged infringements of a fundamental right enshrined in Chapter 4 of the Constitution, or the election of a president or a vice president, the court shall be constituted by all the judges in accordance with the provisions of Section 166, subsection 3A of the Constitution. The jurisdiction of the Constitutional Court is provided for under Section 167 of the Constitution. The Constitutional Court is the highest court in all constitutional matters, and its decisions on those matters is binding on all other courts. It decides only constitutional matters and issues connected with decisions on constitutional matters. The Constitutional Court also makes the final decision on whether a matter is a constitutional matter or is connected with the decision of a constitutional matter. In terms of Section 167, subsection 2 of the Constitution, it is only the Constitutional Court which may advise on the constitutionality of any proposed legislation, hear and determine disputes relating to the election to the office of the President, hear and determine disputes relating to whether or not a person is qualified to hold the office of Vice President, determine whether Parliament or the President has failed to fulfill a constitutional obligation. It is the Constitutional Court which makes the final decision on whether an Act of Parliament or the conduct of the President or Parliament is unconstitutional. It must also confirm an order of constitutional invalidity made by any other court before that order has any force or effect. A constitutional matter is defined in Section 332 of the Constitution as a matter in which there is an issue involving the interpretation, protection, or enforcement of the Constitution. This marks the end of our discussion on the civil courts, and these are the ordinary courts. In our next video, we shall discuss the specialist courts. For the ordinary courts, we have the Magistrate Court, the High Court, the Supreme Court, and the Constitutional Court, with the Supreme Court being the final court of appeal and the Constitutional Court being the highest court in constitutional matters and decisions connected to constitutional matters. Don't forget to like, subscribe, and share your comments in the comment section. Your subscriptions and likes greatly help us continue with the work we are doing here on Legally Dephine. Thank you for watching and see you on the next video.